Good morning, everybody. I have had the privilege of being asked to conduct this webinar, the first that I've ever done, because I'm not a particularly tech-savvy person. But it's a topic which I find very interesting. So, and since we all have a reasonable amount of time on our hands, I think it's an appropriate time to get into a consideration of such matters, which are the sublime levels of law, not matters of everyday issues which you would need in court, but which any lawyer, especially in the area of administrative and constitutional law, should find very interesting and stimulating. That is, what is this Constitution of India? Is it a law? Is it more than a law? Is it a political document? Most times we start our practice and our legal education with the Constitution as a given. Very rarely do we go back to consider, where did the Constitution come from? And I don't mean in the literal sense. We all know it was made by the Constituent Assembly. But I mean, who called the Constituent Assembly? What is their right to make a constitution? How did that constitution get binding on the people of India? What is its legal sanctity? These are the issues which I wish to address in this webinar. So let's start by saying that the constitution of a country, of India, is its basic law, its founding law. From the constitution flow all other organs: the legislature, the judiciary, the executive, the limitations on their power, the scope of the power. From the legislatures flow further laws. But the fundamental question which needs to be addressed, considered and addressed, is really the origins of the Constitution, its basis and its sanctity, whether legal or political. Now, it's necessary to clarify or demystify certain concepts qua constitution. A constitution is per se different from mere law or ordinary law made by a legislature or a law-making body. In fact, a constitution is, if I may say, pre-legal. It precedes the legislatures and their laws. And it, in fact, constitutes the legislatures and gives them the capacity and authority to make laws. A constitution is like the founding law of the state. By an analogy to a company, for example, it would be, though quite inadequate, the memorandum and articles and association of a state. Now, these words in themselves don't mean very much, but there are a couple of observations and passages on the nature of the Constitution of India, one by a judgment of, in Puttaswamy's case, which I think I would like to quote because they put it rather well. In Puttaswamy's case, that's the privacy case, in 2017, Justice Chelaswamy J, I must be Chelameshwar, I think, held in his judgment that a constitution reflects the aspirations and goals of the people of that country, voiced through the language of a few chosen individuals entrusted with the responsibility of framing its constitution. Such aspirations and goals depend upon the history of that society. History invariably is a product of various forces emanating from religious, economic, and political events. The degree of refinement of the Constitution depends on the wisdom of the people entrusted with the responsibility of framing the Constitution. The Constitution is not merely a document signed by 284 members of the Constituent Assembly. It is a politically sacred document created by men and women who risked lives and sacrificed liberties to fight alien rulers and secured freedom. The last words are, I think, most profound. the Constitution cannot be seen as a document written in ink to replace one legal regime with another. It must be seen as a document written in the blood of innumerable martyrs. Profound because it makes it clear that the Constitution is not a law or a mere law or even a basic law. In fact, in the recent judgment in National Territory of Delhi versus the Union of India in 2018, Justice Chandrachud said words which are even more apposite. He said, the Constitution is not merely a legal document. The Constitution embodies a political vision of a plural democratic polity. Hence, any interpretation of the Constitution must be unabashed in accepting the importance of the Constitution as a political document, which incorporates a blueprint for democratic governance. The values which the Constitution, as a political document incorporated, provides the foundations for understanding its text. To perceive the Constitution as a purely legal document would be an injustice to the aspirations of those who adopted it and a disservice to the experience of our society in grappling with its intractable problems. So these are clearly steering words, and they clearly establish that you cannot approach a constitution in terms of a law. Where did it come from? Its legal sanctity, its legal validity. It's far more than that. It is clearly a political document. But these words in themselves, though certainly stirring and very profound, don't completely or fully address the issue of where did the Constitution come from? I mean, who entrusted the Constituent Assembly with the task of preparing the Constitution? What was the basis of their authority? I mean, who gave them the authority to write the Constitution? And how did what they prepared become binding on the people of India? These are the fundamental questions which need to be addressed. Now, having cleared the area that a sanction behind a constitution is not, and it cannot be law, because a constitution precedes law, and it precedes the legislatures. It must follow that the sanction behind the constitution, its framing and its acceptance, is necessarily political. Its acceptance by the people of India is also political and not a matter of mere law. Now, Matthew J. in Keshavananda, the 13-judge judgment which introduced the basic structure concept, dealt with this in two passages which I thought are quite interesting. He said, the vital distinction between constitutional law and ordinary law lies in the criteria of the validity of ordinary law. And ordinary law, when questioned, must be justified by reference to the higher law embodying the Constitution. And this is interesting. But in the case of a constitution, its validity is generally speaking inherent and lies within itself. In other words, the validity of the Constitution lies in the social fact of it being accepted by the people. Its validity is meta-legal. Further, he makes another comment on this, where he says, once it is realized that a constitution differs from law, in that a constitution is always valid, whereas a law is valid only if it is in conformity with the constitution, and that the body which makes the constitution is a sovereign body and needs no legal authority, it becomes apparent that the source and basis of the constitution has to be political authority and not legal authority. In fact, Justice Y.V. Chandrachud, in the same judgment, also said, the fundamental distinction between constitutional law and ordinary law lies in the criteria of validity. In the case of constitutional law, its validity is inherent, whereas in the case of ordinary law, its validity has to be decided on the touchstone of the Constitution. Now, that again raises issues as to who authorized and the Constituent Assembly to make this Constitution, and how did it become acceptable? In fact, it may be noted that most constitutions are expressed to be made in the name of the people of that state or the country. Ours begins with "we the people," etc. But they are not, and they cannot be written by the people. Constitutions are prepared and approved on behalf of and in the name of the people by a small number of people who act as representatives of, on behalf of, and in the name of the people and under their political authority. For example, the Constitution of India was prepared by a Constituent Assembly of approximately 300 persons, one representative for every million of the population. These 300 persons were elected from the provincial legislatures, pursuant to an election to the provincial legislature, in which only 28% of the population had cast their vote. Initially, there were 292 members from British India, 93 for princely states, adding up to 385. But after the Muslim League declined to attend, 80 members left it. Now, as Matthew J. pointed out in Keshavananda, the preamble to the Constitution of India says that we, the people of India, adopt, enact, and give unto ourselves this Constitution. But everyone knows that historically this is not a fact. The Constitution was framed by an assembly which was elected indirectly on a limited franchise, and the assembly did not represent the vast majority of the people of the country. At best, it could represent 28.5% of the adult population of the provinces, let alone the population of the native states. And who would dare maintain that they alone constitute the people at the time of framing of the Constitution? Interesting words. So it was the political movements of the time that motivated and led to the setting up of the Constituent Assembly. The Constituent Assembly, though a constant demand of the Congress Party for years, was in fact not constituted by the people of India, but by Her Majesty's government and the Viceroy, I think it was Wavell, pursuant to the Cabinet Mission Plan of 1946, and on the basis of indirect elections from the provincial legislatures, to which elections had been held in 1946. Now, you will find a complete dearth of judicial discussion and authority on the authority or the basis of the Constituent Assembly. In Keshavananda, there is an observation of Matthew J. on this, where he holds that the Constituent Assembly derived its legal competence to frame the Constitution from Section 8(1) of the Indian Independence Act 1947. And he further holds that the British Parliament, by virtue of its legal sovereignty over India, passed the said enactment and invested the Assembly with power to frame the Constitution. But I believe that this is factually incorrect, though being the only Supreme Court judgment which seems to say where the authority came from, because the Indian Independence Act was passed by the British Parliament in July 1947 to provide for the grant of independence from 15th August 1947. The elections to the Constituent Assembly were held in mid-1946, and the first session of the Constituent Assembly was convened by the Viceroy Lord Wavell by his letter of 20th November 1946, and the session was held on the 9th of December 1946. In fact, Section 8(1) of the Indian Independence Act 1947 did not constitute or create the Constituent Assembly. It only provided that from 15th August 1947, from and after independence, the Constituent Assembly was functioning as the Dominion Legislature. But the Constitution is expressed to be adopted in the name of the people of India and starts with the words, "We, the people of India, having solemnly resolved to constitute India into a sovereign, democratic republic," etc. It is the political will of the people of India expressed through the Constituent Assembly and the political acceptance of the Constitution of India by the people of India from and after 1950 by the various elections that have been held and acts that have been done under it that give it the sanctity and allow it to bind and operate. In fact, Justice Jivan Reddy in Keshavananda put it quite well. He said the fact that the preamble professed in uncertain terms, that is, the people have adopted, enacted, and given to themselves this constitution, that the constitution has been acted upon unquestioned for the last 23 years. That was said in 1973. And every power is purported to be exercised under the constitution. And that the vast majority of people having acted under the constitution elected their representatives to parliament and the state legislatures in 5 general elections makes the proposition indisputable that the source and the binding force of the constitution is the sovereign will of the people of India. So that's the first part of it. Now, as we go further, we have seen that constitutions are basically and inherently political documents. They embody political views, hopes, aspirations of the people at that time. They also embody compromises of conflicting political demands, forces, and the language used in a constitution must necessarily take content from the context of its times. Moreover, constitutions do not work on their own. The persons who man the institutions created and recognized by the Constitution, and particularly the superior judiciary, shape how a constitution adapts to the context and reality of a time. A constitution, as I will show, is as good as the courts and the judges who are its sentinels. Now, I'll take a very brief 5-minute detour into American constitutional history to establish this before coming back to India. Now, the US Constitution was written and approved in Philadelphia by 55 delegates representing the states existing in 1787. It used the words, "We, the people of the United States, in order to form a more perfect union, etc., etc., do ordain and establish this Constitution for the United States of America." And before that was the US Declaration of Independence in 1776, which said, "We hold these truths to be self-evident, that all men are created equal, that they're endowed by their Creator with certain unalienable rights, that amongst these are life, liberty, and the pursuit of happiness." But big words, or words for that matter, do not always mean the same. Now look at the words of the Declaration of Independence. All men are created equal. And that was supposed to be a self-evident truth. But in fact, viewed in today's spectacles, it was totally misleading. Because the colored people, the slaves, who by then constituted 20 to 40% of the population of the southern states, were certainly not treated as equals or included. Women were also not included because they were given the right to vote only in the mid-20th century, in 1930s. Even non-propertied whites were denied the right to vote. So the language might look sweeping and wide, but its context is necessary to realize what it actually meant. Now, for example, constitutions embody constitutional compromises between diverse political forces. For example, when the US Constitution was under preparation, there were two fundamental issues, political issues, that needed to be resolved before a constitution could be agreed to. One was how to reconcile the claims of the big Confederate states with the claims of the small Confederate states, since all states were to enjoy equality of status. And secondly, should the importation of slaves be prohibited? One view was that slavery was immoral and the importation of slaves should be prohibited at once. In fact, from 1777 to 1804, the northern states had abolished slavery. The other view of the southern states was the contrary view, that slaves were property and the rights of property ought not to be interfered with. The framers of the Constitution were convinced that unless a compromise could be reached on slavery, North and South Carolina and Georgia would refuse to join the US. So a constitutional compromise was evolved. The first problem was solved by providing that while Congress, the House of Representatives, would be based on popular representation, each state, big or small, would send two representatives to the Senate. The issue of whether slaves were to be included while accounting for population, for congressional representation, and consequently the number of representatives, was tackled in an even more interesting manner. Because at that time, don't forget, the slaves' population represented 40% of the total population in some of the larger southern states. This requirement of popular representation to the Congress and what to do with the question of whether the slaves at that time, the colored people, should be included or not, was resolved by providing in Article 1, Sub-Article 3 of the US Constitution, that the number of representatives would be determined by adding to the number of free persons, presumably white property persons, 3/5 of all other persons, which was a euphemistic reference to the slaves. And this constitutional compromise is still on the books of the American Constitution in Article 1, Sub-Article 3, which enabled colored slaves to be counted as 3/5 for the purpose of determining congressional representation. And based on those extra votes, the first 12 of the 16 presidential elections of the US, Southern votes computed on this basis were crucial in securing the election of slave owner Southerners as presidents. In fact, George Washington wrote that the Constitution we now present is the result of amity and that mutual deference and concession with the peculiarity of our political situation rendered indispensable. In fact, it required a civil war to be fought before slavery could be abolished. From 1865 to 1869, the 13th Amendment was passed, which abolished and prohibited slavery. And the 14th and 15th Amendments were passed, which granted US citizenship to all persons born or naturalized in the US and prohibited discrimination on the ground of race and color. And to get these amendments passed required a lot of political maneuvering. It is commented that to get support for this amendment, Lincoln promised government jobs, campaign contributions, and Representative Thaddeus Stevens has stated that the greatest measure of the 19th century was passed by corruption, aided and abetted by the purest man in America. Even thereafter, there has been all this issue about separate but equal which held the field from 1890 right up to 1956, in which American courts said that there would be equal treatment, but there would be no difficulty or prohibition against separate treatment. And this continued all the way up to 1954 in the Brown versus Board versus Education case, where busing was challenged and the court held that racial segregation was bad in law and the separate but equal doctrine would not apply. I digress just for a few minutes to say that important constitutional pronouncements often have a history which most people can't see. Brown versus Board of Education, where racial segregation was challenged in the busing systems in schools, was actually almost decided the other way around, upholding the separate but equal doctrine. The Chief Justice at that time was Chief Justice Vinson, and he started writing the majority or the unanimous opinion, upholding Plessy versus Ferguson and separate but equal. But he died before he could complete the judgment. Earl Warren was appointed Chief Justice, and he surprisingly now persuaded the entire court to decide the other way and overruled Plessy in educational matters. In fact, when he learned that Justice Vinson had died, Justice Frankfurter is supposed to have said, and I quote, that this is the first indication I have ever had that there must be a God, unquote. The American experience is important in as much as shows us that it's not the words of a constitution, but the superior courts which interpret and give content to the principles underlying the same, which really make constitutions. For example, in the words of Justice Thurgood Marshall in 1975, in the case of Regents of the University of California versus Back, he said, the same liberal US Constitution, as interpreted by the US Supreme Court for 200 years, did not prohibit the most ingenious and pervasive forms of discrimination against the Negro. So when you look at the liberal content of the American Constitution, or you look at the manner in which constitutional doctrines are expounded by our Supreme Court, you must remember that the content and force of a constitution is only as good as the superior courts that interpret and enforce it. Now, to go back to India, as I mentioned earlier, during the pre-independence struggle days, there had been a consistent demand by the Congress for setting up a Constituent Assembly. In 16th May 1946, the Cabinet Mission Plan was formulated and announced by a committee of 3 members. The steps contemplated first preparatory discussions with elected representatives of British India and with Indian states in order to secure the widest measure of agreement as to the method of framing a constitution, and second, the setting up of a constitution-making body, and the third, the bringing into being of an executive council having the support of the main Indian parties. There was disagreement between the Congress and the Muslim League on the nature of the proposed interim government. And finally, on 16 June 1946, the Viceroy announced the formation of the interim government and directed the governors of the provinces to summon provincial legislative assemblies forthwith to proceed with elections necessary for setting up the constitution-making machinery as per the statement of 16th May. The Constitution of India was prepared by a Constituent Assembly of 389 persons elected from the provincial legislatures, which provincial legislatures had been elected pursuant to an election in which only 28% of the population of India then had voted. And on the 20th of November 1946, the Viceroy summoned the Constituent Assembly for its first meeting on 9th December 1946. The Constituent Assembly worked from 1946 to December 1949. And the Indian Independence Act 1947 was passed by the British Parliament in July 1947 to provide for the grant of independence from the 15th of August 47. And Section 8(1) of that act provided that from 15th August, the Constituent Assembly would function as the Dominion Legislature. India's Dominion status continued till 26 June 1950, when the Constitution came into force and the Indian Independence Act was repealed. Mr. Ambedkar introduced the draft Constitution in 1948. It had 315 articles and 8 schedules. It was the bulkiest constitution yet. The Constitution came into force on 26 June 1950, Republic Day, and on that day the Assembly ceased to exist and transformed itself into the Provisional Parliament of India until a new parliament was elected in 1952. In the Constituent Assembly debates, there was a considerable debate about the preamble and its contents. There was a considerable debate on whether there should be any reference to God, and it was rejected as being contrary to the freedom of faith, which was guaranteed as a fundamental right. An amendment to add the words secular and socialist was defeated after Mr. Ambedkar said that to include in the Constitution itself whether India's social and economic organization would be socialist or capitalist would be to destroy democracy, and that should be open to the people of the country to choose the type of social and political organization they wanted to live in. Interestingly, the preamble was adopted last, after the body of the Constitution had been fully approved and its content accepted, to see that it was in conformity with the Constitution as accepted. It may be noted that by the Constitution 42nd Amendment Act, the words socialist and secular were added to the preamble. But these words were not defined, and their definition itself is a matter of debate. By the Constitution 44th Amendment Act, definition of these terms was sought to be added in Article 366. Broadly speaking, the word secular was sought to be defined as equal respect for all religions, and the word socialist as freedom from all forms of exploitation, social, political, and economic. The amendment failed in the Rajya Sabha and never became law, but the words remain in the Constitution. In fact, every article of the Constitution, Article 14, Article 19, Article 21, Article 32, all of them raise issues of political compromise. For example, the Indian Constitution, very briefly, resolved a large number of issues as to the nature of our polity and our country. But there were many other issues which were more intractable. These issues were relegated to Part 4, the Uniform Civil Code, the national language, even Article 48A relating to cow slaughter, in the hope and belief that with the passage of time, prosperity, education, these issues would be resolved in a less contentious manner, which would add to the constitutional strength of India itself. So friends, this has been a brief but a rather far-ranging talk on the origins of the Constitution, what gives it its basis and its strength. But we must realize, and I stress this today, that the Constitution is only as strong and as clear as the constitutional courts which interpret and enforce it. It's too late and too in the day for this talk to delve into the matter of how far those hopes and aspirations have been maintained and where we stand in the matter. Maybe that would require another talk and a completely different time. But I trust and I hope that this brief talk has shed some light on the basis and sanctity of our Constitution and to differentiate it from laws which have legal sanction and which ultimately flow from the Constitution. I thank you. I hope it hasn't been too long, and I hope it hasn't been too technical either. But it's a topic that has entranced me, and therefore I was quite happy to spend this time dealing with the same. Thank you.
Thank you, sir. We have a few questions which have come in.
Sure.
The first question is from Sushrut Prabhudesai. He says that if the Constituent Assembly was the only body of persons which was authorized to write the Constitution, and if now the Parliament has stepped in its shoes, then can the Parliament rewrite the Constitution?
Well, after Keshavananda, the principle is been that yes, you can amend the Constitution, but you cannot amend it so as to affect its core or basic structure. And they've highlighted what are the elements that constitute the basic structure. So the Parliament today has a constituent role in as much as it has an ability to amend the Constitution. But that power itself flows from Article 368 and flows from the Constitution. And therefore, the basic structure doctrine enunciated in Keshavananda is the limit to which parliamentary amendment can go, not beyond. I hope that answers that.
So the other question that we would like to put to you is, if the Constitution itself has the power to amend it, on what basis can deletion of the provisions take place?
Deletion of which provisions?
Of the constitutional provisions. For instance, Article 19F was deleted at one point. So at what point, it's sort of in the ship of Theseus sort of a way, at what point does the Constitution cease to be the Constitution as we know it and completely changes its structure?
That goes back to Keshavananda once again. They say that the power to amend can be exercised so long as the basic structure, the core, the separation of powers, the power of judicial review, the power of having democratic and free and fair elections, various other elements that they've delineated there, those are beyond the amending powers of Parliament. Short of that, anything can be amended by Parliament in exercise of its constituent power.
Just two more questions, sir. Do you think the Constitution is being used or can be used by a legislature to fulfill its political agenda?
The Constitution is a political document. The Constitution cannot be used or misused. The Constitution is a social compact between the people of India. It might be that political parties seek to push their agenda to levels which might constrain or come into conflict with certain aspects of the Constitution. If that is so, then it's a matter for the courts, because the courts are the sentinels and the protectors. Political parties, hopefully, will act within constitutional constraints, not merely the letter, but the spirit which permeates the Constitution, constitutional morality, as they've said in the Supreme Court, in furthering their agenda. Unfortunately, at times the letter of the Constitution seems to be more important than the spirit of the Constitution. But in all those cases at the margin, where political agendas might seem to transgress constitutional principles, the matter necessarily has to be resolved in the apex court and by the apex court.
So one last question for you. Do you think the Constitution is a legal document which has been created by political means?
It is a legal document in as much as it has legal force in the creation of all the institutions of the state and the limitations thereof. But it is not a mere legal document. Its origin is political. Its effect might be legal, but it gets that legal effect because of the political sanction and the political acceptance. There has never been a vote by the people of India to accept the Constitution or not. Once the Constituent Assembly framed it and approved it, and it came into force, it is the acts of the people in acting on it in diverse national elections, in treating it as a fundamental law, that gives it its political sanction.
Thank you, sir. We have a lot more questions coming in, but due to paucity of time, it may not be possible to take them up right now. But on behalf of all of us, I'd like to thank you very much for conducting this talk. When we first spoke, I could sense the apprehension in your voice about the technical aspects of this. But I'm happy to see that you were able to overcome that and attend and deliver this talk to all of us today. I
must say that the kudos go to you, because if you hadn't pushed me a bit and enthused me enough with my normal reluctance about all these internet stuff, I would have balked at the issue. But it was your persuasiveness more than anything else on that.
No, my persuasiveness was because of the numbers that we are seeing today. We already have about 480 people attending on the app and close to 200 people attending on YouTube. That shows your popularity and how excited people were to hear you. You have kept a few topics open, which we have noted down, and we will be calling you back soon to deliver a lecture on that topic, hopefully in better circumstances, hopefully in a more intimate setting than the internet. But thank you very much, sir.
Thank you, Abhay. And best wishes to everyone hearing, and hopefully we'll be able to meet in court soon. Thank you.
Thank you. For all our attendees, just a quick update from Team deBrief. We will be posting this on YouTube. Our next talk will be on this Friday, again in the morning at 11:30. We are going to move slightly away from the academic talks, and we are going to have an interview of Mr. Chandar Uday Singh, who is a senior advocate practicing in the Supreme Court. The interview will be conducted by one of his juniors, who is Advocate Ila Sheel, to make it a little more candid. On Monday, we will have Mr. J.P. Kama delivering a lecture on labor laws in the present scenario. And on Wednesday, next Wednesday, we will have Justice Damasheshadri Naidu, who is a judge of the Bombay High Court, to deliver a lecture on federalism. So I hope all of you can join us for that. Please follow us on our social media platforms. All the official updates relating to all our events will only be made on the social media platforms. And please also like, subscribe to our YouTube channel. Thank you very much.